In this episode, I would like to discuss about violation of one important clause, that is clause 3 of section 5 of the Hindu Marriage Act 1955. We know that according to clause 3 of section 5 of Hindu Marriage Act, the marriage between two Hindus can be solemnized if the bridegroom has completed the age of 21 years and the bride has completed the age of 18 years. So, if this condition is violated, that means bridegroom or bride, if they have not achieved that age, that means they have not come to the age of either 21 years in case of bridegroom and 18 years in case of the bride, what will be the consequence? So, that means if any marriage between two Hindus takes place in which the age of bridegroom is below 21 and the age of the bride is below 18 years, then what will be the legal consequence of such marriage? Whether that marriage will be treated as void marriage, or whether it will be considered as voidable marriage, or whether it will be considered as valid marriage. Though at present situation it is very much discussed by the government, central government, that age limit in case of women regarding Hindu marriage will be increased up to 21 years of age, but it is not yet implemented. It is at present in the stage of bill. So, act has not been amended or it is yet passed. So, for still now the age limit is in case of bridegroom 21 years and in case of bride 18 years. So, if that is violated, what will be the consequence? That is the topic of discussion of today in this episode. Section 5 of the Hindu Marriage Act 1955 deals with the conditions of marriage. It prescribes 5 conditions for solemnization of the Hindu marriage. It says that a marriage between two Hindus can be solemnized if 5 conditions are satisfied. So, first is neither party has a spouse living at the same time. Second, neither party is incapable to give a valid consent because of unsoundness of mind, or though capable to give a valid consent has been suffering from mental disorder of such a kind as to unfit for procreation of the children, or has been subject to recurrent attacks of insanity. Third condition, third clause says that the bridegroom has completed the age of 21 years and bride has completed the age of 18 years. Clause 4 says that neither spouse is within the prohibited relationship, and fifth clause says that neither party is within the sopindo relationship. So, these 5 conditions are to be satisfied for solemnization of a marriage between two Hindus. Now, what will be the consequence if either of these conditions are violated? So, if clause 1 of section 5 is violated, that means if any party has a spouse living at the same time, that means second marriage, then it is called bigamy, and which is punishable in accordance with law. Then what will be the consequence, or what will be the consequence if they are not of sound mind, or what will be the consequence if the age limit is not reached by the parties? That means bridegroom is below the age of 21 years and bride below the age of 18 years. What is the topic of discussion today particularly, and what is the conditions of violation of clause 4 and 5? That means if the parties are within the either prohibited relationship or shop into relationship, what will be the consequence. So, let us have a look about section 5 of the Hindu Marriage Act and section 11 and 12 of the Hindu Marriage Act. Now, section 5 prescribes that 5 conditions, as I have already stated, that neither party has a spouse living at the same time, neither spouse is incapable of giving a valid consent either by any of the following reasons: first, unsoundness of mind; second, mental disorder; and third is recurrent attacks of insanity. Third, bridegroom has completed age of 21 years and bride has completed age of 18 years. Fourth, parties are not within prohibited relationship, and fifth, parties are not within shop into relationship. Now, if these conditions are violated, what will be the consequence? If first condition, fourth condition and fifth condition violated, then it is mentioned in section 11 that such marriage will be treated as void marriage. So, if first condition or fourth condition or fifth condition of the Hindu Marriage Act, that is neither if any spouse is living at the same time or they are within either prohibited relationship or shop into relationship, then marriage will be treated as void by virtue of section 11 of the Hindu Marriage Act. In case of violation of clause 2, this clause, it is mentioned in section 12 that such marriage will be voidable marriage. What are the grounds of voidability? It is mentioned over there. First is impotency, second is violation of clause 2 of section 5, this clause. Third, consent obtained by fraud or pregnancy by other person. So, if any of this condition is violated, then it is hit by section 12. So, what appears to be finally? That for violation of 1, 4th and 5th, it is hit by section 11 and marriage becomes void. In case of voidability, if there is violation of clause 2 of section 5, it is voidable by virtue of section 12 of the Hindu Marriage Act. There are other grounds and clause 2 is inserted within it, but it is not mentioned either in section 11 or section 12 that what will be the consequence of contravention of clause 3 of section 5. That means, this condition if violated, what will be the consequence? It is not mentioned in either section 11 or section 12. So, we can say that it is not intention of the legislature to declare such marriage as either void or voidable. So, that is not intention of the legislature to declare such marriage as either void or voidable. So, what remains, that is valid, because we know that marriage is a contract as well as sacrament. So, the consequence of any marriage may be either of these three. It may be valid or it may be void or it may be voidable. So, from the discussion it appears that such marriage violation of clause 3, violation of clause 3 of section 5 does not make the marriage neither void nor voidable, since it is not hit either by section 11 or section 12. Then violation of clause 3 of section 5 is not mentioned in either section 11 and 12. So, what will be the consequence? Marriage will be treated as valid marriage. Why? Now, I would like to discuss about that. Now, I would like to discuss about other two sections of the Hindu Marriage Act, that is section 17 and section 18. Now, in these two sections, some more punishments are prescribed for violation or contravention of various conditions of the Hindu Marriage Act. Now, let us have a look in section 17 and 18. Section 17 says punishment of bigamy. That means if there is violation of clause 1 of section 5, that means if either spouse is living at the same time, it is bigamy. So punishment is given in section 17 that the marriage is void so far Hindu Marriage Act is concerned, section 11 is concerned, but apart from that, section 494 and 495 of the Indian Penal Code will be followed in accordance with law. That means punishment of bigamy will be followed as it's mentioned in section 17 of the Hindu Marriage Act. That Indian Penal Code 1860 prescribes the punishment of bigamy, and that's why section 494 and also 495, that means second marriage, concealing the fact to the other spouse, both are punishable, that will be followed. And in section 18 it is said punishment for violation of clause 3 of section 5, that is rigorous imprisonment up to 2 years or a fine up to rupees 1 lakh. And for violation of clause 4 and 5 of section 5, simple imprisonment up to 1 month or fine up to rupees 1000. So again it is stated some additional punishments for violation of clause 1, 4 and 5 and also 3 of section 5. It says that if clause 3, that means today's subject matter, if clause 3 of section 5 is violated, that means bridegroom is below the age of 21 years or bride is below the age of 18 years, it is stated that 2 years rigorous imprisonment can be imposed, and in addition to 1 lakh rupees can be fined maximum. And also in case of violation of clause 4 and 5, that means if the spouses are within the either prohibited relationship or shop window relationship, the punishment may extend up to simple imprisonment for 1 month or with fine which may extend up to 1000 rupees. So these additional punishments are prescribed. So what appears to us that for violation of clause 3 of section 5, what is today's topic of discussion, that if it is violated, then there is one consequence that the parties are to suffer the imprisonment, rigorous imprisonment, which may extend up to 2 years or a fine up to rupees 1 lakh rupees, as mentioned in section 18 of the Hindu Marriage Act. But fine is mentioned over there, rigorous imprisonment is mentioned over there, but it does not mean that marriage is either void or voidable, because that is not hit either by section 11 or section 12, as I discussed a little bit earlier. That's true that marriage is neither void nor voidable, but if clause 3 is violated, consequence is to face, the parties have to suffer rigorous imprisonment up to 2 years or fine up to rupees 1 lakh. But marriage is valid, and why the marriage is valid, it can be supported by discussion of a Latin maxim that is called factum valet. So now I would like to discuss this Latin maxim factum valet, by virtue of which we can say that marriage is a valid marriage, though bridegroom has not completed the age of 21 years or the bride has completed the age of 18 years, still marriage will be considered as valid marriage by virtue of application of the doctrine of factum valet. Let me discuss about this doctrine right now. The Latin maxim factum valet or factum valet po fieri debut, it means that act which should not be done is valid if it is done. So that means if any act has done in irregular manner, not in accordance with strictly following the rules and regulations, still by virtue of this doctrine it is valid. A Roman Latin maxim, it was very frequently used prior to the enactment of the Hindu Marriage Act 1955, because prior to that all Hindu marriages were dealt by our various dharma shastras. So, if there was some irregularity in case of marriage, so they were considered as still valid by virtue of this application. That means, act done though in irregular manner, but still it is valid, and it was also applied by the Britishers in our court in case of governing the matrimonial cases. So, during British time also this doctrine has the application. So, that means that it though there is some defect in the marriage, it can be cured by application of this doctrine. So, what section 5 says, that clause 3, that bridegroom should attain the age of 21 years and bride should attain the age of 18 years, but if that is not strictly followed, marriage does not become void. Marriage is still valid by virtue of the application of this doctrine, that is factum valet quod fieri debut, in short factum valet. That means, act should not be done is valid when it is done. So, since marriage takes place, so marriage is not becoming void thereby. So, what can be said, that marriage is valid though there is this irregularity. Actually, Britishers during the matrimonial suits, they applied this doctrine following the principles of equity, justice and good conscience, and later on also in various cases it is followed. So, what is the position, that if the bridegroom has not completed the age of 21 years and the bride has not completed the age of 18 years, by virtue of the application of the doctrine of factum valet, the marriage is still valid.